He was sentenced to 25 years for killing our 2-month-old daughter.
Of Sierra's interview, she indicated that she did not know of any reason why Mahogany would be in distress, why she would pass away, that she was healthy, had no previous medical conditions. And after law enforcement leaves her alone in the interview room, she makes a comment that he took my child from me, which led them to believe that there was something going on with this defendant. He did not initially return to the scene when law enforcement requested that he do so. He did eventually agree to an interview. During the course of that interview, he made several incriminating statements, whereupon he begins explaining injuries that he would otherwise not have any reason to know had occurred. He indicates that he dropped the child accidentally, that he may have bumped her head several times, and at that point, medical examination had not been completed, and so there was no way otherwise for him to know that she did have head injuries. He also indicated that he wanted law enforcement to apologize to Sierra for what he had done, and indicated that he knew that Sierra had not hurt the child, which only leaves the two of them as the possibilities. And he indicated that he knew Sierra did not hurt the baby, and had explained injuries that at that point we did not know that Mahogany had. During the course of the medical examination, it was determined that Mahogany had broken ribs and also brain injuries and petechial hemorrhages, which are consistent with a rotational force or a shaking of the child. She also had healing rib fractures as well. Those were injuries that would have resulted in a very quick death, which is what occurred here. They were determined to be inflicted injuries or traumatic injuries, and therefore the cause of death was ruled to be homicide. Judge, I will note that discovery was provided to the defense back in December, and shortly after reading all of the discovery, including the medical examination records and the interviews, especially the interview of this defendant and the statements that he made, counsel for the defense is the one that reached out to me to determine if this was a case that could be resolved. Based on all of our discussions, the state has agreed to allow the defendant to plead to a lesser included offense of count 1. That is going to be murder in the second degree, which is based on a cruelty to children in the second degree. It's generally based on criminal negligence, which is a compromise plea in this particular case. The range of punishment for murder in the second degree is 10 to 30. We have a negotiated plea of 30 years to serve 25.